All right, well, I'm here today with Mr. Matt Staver, head of Liberty Counsel, and we're just going to go over part of the McCreary case and just an understanding of the whole process and how it all works. And so I wanted to start off being the head of Liberty Counsel. What is Liberty Counsel?
Liberty Counsel is a religious liberty public interest law firm that defends religious liberty, the sanctity of human life, and other constitutional rights all over the country. We do that at no cost, pro bono, and we've been in existence since 1989. I've argued twice before the U.S. Supreme Court, written scores of briefs before the High Court, and argued at the various federal courts of appeal and state Supreme Courts all over the country.
So how do you typically get clients?
They contact us. They either know about us through word of mouth, or now we have radio programs. We're on over 500 radio stations every day, and then that's with our Freedom's Call radio program. We're on over 100 radio stations with a different one called Faith and Freedom. We have lots of different educational and other outreach sources. People know about us, word of mouth, or they can look us up online, and that's how they contact us.
Okay, so but this is definitely not a typical law practice where people knock on the door. It's through the contacts of the radio. Sometimes doesn't even people in Congress or someone like that contact you.
Members of the elected officials, when they know something and their constituents ask them about an issue, they'll refer them to us because it's not something obviously they do. Other pastors, business leaders, individuals, they'll refer friends or people who need help to us. So there's lots of different ways, but the typical ways we'll get an email or a phone call, and then we follow up with conversations and communicate directly with the client.
So how did you come to represent McCreary County in this issue?
A number of people from McCreary County and Pulaski County, another county, and also Harlan County, which was where the Ten Commandments were displayed in the same way in a school district office. They came to Orlando to meet me and laid out the cases and asked me if I would be interested in taking on the representation. We reviewed the facts of the case and we agreed that they were worth defending, and so we became the counsel of record and argued the case at the lower court, the Court of Appeals, and eventually at the United States Supreme Court.
So I guess there's a process here, because I'm sure you get lots of calls, lots of people that would like Liberty Counsel to represent them. Like, what is kind of your thought process when deciding, what cases to take?
We look at the facts, we look at the law, and we look at the client. Those three are very important. You can have the law on your side, but very bad facts. And so if you're looking at setting precedent nationwide, you want to make sure that you have the best fact pattern as possible. You can't always control that. Sometimes you have some facts you would rather not have. But those are the three: the facts, the law, and the clients.
Can you give us just some basic facts of this case?
Yeah, the McCreary County and Pulaski County, they're both courthouses. And then Harlan County was a schoolhouse, and that was also part of what went to the U.S. Supreme Court. We won the Harlan County case. The Pulaski and McCreary was the primary ones before the U.S. Supreme Court. And they started off in a similar way. They started off with the display of the Ten Commandments, and then there was a challenge to that. They ultimately modified the display, and they included some other historical documents that were excerpted. And then by the time we got on the case, they ended up expanding the display that included the Ten Commandments and then non-excerpted documents of American law and government. That would include non-excerpts from the Declaration of Independence or the Bill of Rights particularly was one of them. The Magna Carta was another. The entire Magna Carta was reproduced rather than excerpts from it. And that was the display that ultimately went up to the United States Supreme Court. So the issue at the United States Supreme Court, although it should have been on the face of this display, does this display, as it now exists, violate the First Amendment Establishment Clause? That's a fairly straightforward question, and the answer to that, other courts have routinely stated, subsequent to McCreary, no. It is consistent because it includes other documents besides the Ten Commandments. And by the way, the Ten Commandments has both a religious and a secular component because of how it has influenced American law and government. I can explain that in quite detail. But what the Supreme Court did instead is they looked at the intent, the subjective intent, in that particular case of the people behind the display. Was their intent something that was purely educational and secular, or was their intent religious? The problem with looking at some subjective intent is you can have a good intent with an unconstitutional result. It doesn't mean that you uphold something as constitutional because someone had a proper intent. On the other hand, you could have an intent that's not necessarily constitutional, but the result of it is constitutional. The bottom line is these displays should be judged on their face as opposed to someone's subjective intent. And what the court ultimately came down and ruled is that in that case, at the preliminary injunction level, not the final decision, that the subjective intent was primarily religious because it started off as a single display, then an excerpted display, then eventually a constitutional display. But as a result of that case, we ended up winning the Harlan County School Board case involving the same display that came into existence with everything at once rather than a previous history. And we won every other display after that. We've never lost a Ten Commandments display case, whether it's a standalone case or it's a display case involving the Ten Commandments and other historical and governmental documents since the 2005 Ten Commandments case at the Supreme Court.
What about, so that day, there's another case, the Van Orden case. Why do you think the court saw that differently? Was it just the
Well, this is really an illustration in the starkest way about the absurdity of what the Supreme Court has done to the First Amendment Establishment Clause. And in fact, that issue is up before the Supreme Court now in the Peace Cross as to whether they'll overturn some of these bizarre precedents known as the Lemon test, coming out of the case of Lemon versus Kurtzman, and then later on the reasonable observer test that O'Connor invented. McCreary County was a display of the Ten Commandments in the midst of lots of other historical documents, with an explanatory plaque about each one that just was very descriptive with no commentary. Van Orden was a 6-foot-tall, 2-ton granite monument that was placed out in front of the Texas state capitol, and it actually had in big letters at the top about obeying God and honoring God. Then it went through the different excerpts of the Ten Commandments. Everyone predicted in moot courts and commentaries that the Supreme Court would unanimously side with our case and unanimously side against the granite monument. But in fact, they upheld the granite monument. And in our case, McCreary County, they used the Lemon test. And with the Lemon test, they didn't look at the actual display itself. Did it have as its primary purpose the advancement of religion? What would a reasonable observer see when you're looking at this display? Was its primary purpose an advancement of religion? The answers to that would be obviously no, and that's why we won every case thereafter and any case that started off with just this display. But instead, using the Lemon test, they looked at subjective intent. Was the original intent of the people who displayed it primarily religious or secular? And they ultimately concluded that they were primarily secular or religious, and therefore at the preliminary injunction stage, we lose, but the case could continue to go on and progress below. On the Van Orden case, the question is, what test would they use? Would they use the Lemon test? Is this monument, does it have as the primary purpose the advancement of religion? There's nothing else around it. Is it the Marsh test, the historical test, that the Ten Commandments was in existence at the time of the First Amendment, and therefore the drafters would not consider it to be unconstitutional? They didn't use any test. They just simply said, well, it had been in existence for about 40 years and nobody complained, so it's grandfathered in. They never gave any hint as to how long you have to be in existence? Is 40 years the magic number? What about 20 years? 10 years? What about something that is even more religious in nature, but it's been there for, as the Peace Cross, 93 years? So none of that was discussed. And this was simply Justice Breyer, being the swing vote on that case, deciding that he wanted to reach that result, and that's where he ultimately decided to go. And so he was really the swing vote on that case. On the other one, it was O'Connor. That was her last week on the bench when this was decided and handed down. And she didn't want to give up her legacy of the endorsement test, so she wanted to not jettison the endorsement test in Lemon. So they came up with this other bizarre thing to look at the past history intent as opposed to what a reasonable observer would actually see. And, you know, a reasonable observer on this particular case, 5, 10, 15, 20 years later, seeing the exact display, a reasonable observer is not going to go back into the annals of history and read old newspapers to find out how this display actually began. What was their original motivation? The reasonable observer is going to see what they see at that moment and make a decision. But she did not want to overrule that, and so she and Justice Souter concocted this bizarre analogy to look at long past intent as opposed to current displays.